Can you walk us through what's a fair, legal, compliant disciplinary process, and what should it look like for a business? So this is a really common question.
Yeah.
We're getting on from the membership team, the legal team, I'm sure. So can you just briefly talk us through that?
So broadly, a fair disciplinary process has at least 2 stages, maybe 3. So the first stage is an investigation. The second is a disciplinary hearing. And the third one is an appeal, if the employee chooses to use that appeal. So often when we're dealing with employees and we're dealing with businesses who phone us about a disciplinary procedure, we're always saying to them, look, please phone us as early as possible, so we can get the investigation right. Because if the investigation isn't right, we're going into the disciplinary hearing too soon, and then we're kind of setting ourselves up for a fail. So, and this is particularly true with what we were discussing earlier with the change to the threshold for unfair dismissal moving from 2 years to 6 months. Many more people will be captured by this process that if we get it wrong, they'll maybe be able to attempt a claim at the employment tribunal. So if you've ever kind of relied on the fact that, oh, well, I can just go in and pull somebody in after 18 months and say it's not working, particularly if it's a conduct related issue, you won't be able to do that now. So this has become, it's always been important, but it's become doubly important now, given the fact that so many more people will be covered by this from a disciplinary perspective.
Sure. So what are the most common errors that employers make? Well, there's mistakes as such that during the process that they tend to get wrong, as I say, in respect of support or however, and we can follow that one up, as you said, you briefly touched on it, and what potentially could happen by not following the process.
So the first thing is, I think employers try and rush the process. Disciplinary processes are serious things. They can't be rushed. They've got to be dealt with soberly. You can't just do it on a Monday and have an outcome on a Wednesday. You've got to take your time with it. Think about who your witnesses are going to be. Think about what sort of data that you might need. Is there CCTV footage? Is there clocking out records? Who was present? Who were the witnesses? How am I going to speak to them? Am I going to get them in for an investigation meeting themselves? Or am I going to ask them to write a statement? All of those things. So get your plan considered early on. Don't try and rush it, and phone us. So it's the important point, because we'll be able to say, well, have you thought about this? What have you done in the past? That's another important point. If this was dealt with informally in the past, think about why that was. Could we deal with it informally in the first instance before having to go through a lengthy disciplinary procedure? What are your policies? What are your procedures? What procedure and policy has this person allegedly breached? When we bring them in for an investigation meeting, can we point to something? Were they aware of it? Have they been trained? So there's lots of things people can maybe dive in head first and say, right, I'm going to discipline this person, or tell them that they're going to get a warning. That's a classic. There should be no decisions made in advance. Nothing should be predetermined at that point. Also think about who is going to do the investigating, who is going to be the disciplinary manager, and who is going to be the appeal. The ACAS code clearly states that ideally that a different person should be holding each stage to give that independence at each point. So whoever's chairing it can look at it independently at that point. A lot of your members are small businesses. They might not have a huge sweep of managers to be able to do it. So there might be examples where you think, well, I simply don't have the scope in order to do that. But think about it in the first place. Maybe you think, actually, no, I can do the investigation, I can do the appeal, but I do have somebody else. I can do the hearing, but maybe somebody else can do the appeal. So think of those things. So the key mistake is that people rush it. They think, oh, well, all I need to do is interview just one person and go straight to hearing, give them 2 hours notice and tell them they're going to get a warning and do it. No, do it. It's a serious thing. Give it the respect it deserves and really plan it so that when you go and do arrive at the process, that you've got your eyes wide open.
I think, as like you said as well, you refer to it as the legal helpline. You said earlier on, the helpline advisors are not just there for that one-off phone call. It's not, I can only ring them today and I can't ring them again tomorrow. They are there to offer that support all the way through that process. They can take you step by step by step, provide template to, listen to your concerns and whatever else, because, and you touched on it, it can be quite an expensive mistake to make if you don't do the process properly.
It can.
So have you got any sort of examples? Or
so
anything you can...
So I think a key point here is that if you are taken to an employment tribunal, even if you've got the strongest case in the world, right, and you may well have, there's time and cost of running a tribunal.
Yeah.
First of all, your own stress of having to be kind of knowing that you've got that hanging over you. There is the preparation time. There is, and if you want to engage a solicitor to represent you, they have their costs. So before you even get to the tribunal itself, there's the time and effort of going through that, and really you just want to be focusing on running your business. So if an employee is determined to take you to an employment tribunal, that's up to them. And they will, and we can't force them to not make that decision. We can maybe try and settle with them later on. But what I would say is don't hand the employee an open goal by failing to follow the process correctly during the initial investigation and disciplinary hearing and appeal. Because even if you're absolutely spot on with the decision that you've made, if you've fallen down procedurally, you could really scupper your chances at that point. Particularly, and there's absolutely no need to fall down procedurally, because you've got us on the phones, you can speak to us, we can provide you with guides, we can talk you through the process. So don't feel as if you need to wing it. You really don't. There's so much support out there. And going back to rushing it again, if an employee goes off sick during the process, which they often do to try and avoid it, don't panic, phone us up and we'll talk you through the process. There's things you can do. Don't just say, oh, well, I'm going to make a decision in their absence and without giving the opportunity to attend. There's things that we can do. Or don't think, oh, well, I'm going to just do a half job in the investigation because I'm really busy and I need to get things done. I'm not going to have this person ruin my week or my month because I'm going to deal with it. No, take your time, be patient, because I guarantee you in 18 months' time, when you're faced with an employment tribunal claim, the few weeks that you could have spent getting it right will suddenly feel as if it would have been a flash. And so, be patient with it, I would say.
I think it's also worth noting that is not to think that the employee, that member of your team isn't also getting support their end. Because some people also think that, oh, they don't know what they're doing. But obviously ACAS is there to support the employee. So if you take a wrong step, somebody else is going to pick up on that.
I think we need to mention ChatGPT and AI.
Glad you brought up AI. I was going to do that.
Because things that employees necessarily may not have known about before, they're being notified of it and they're becoming aware of it through AI. Some of it is complete nonsense, but some of it is real, and things that were probably previously pretty niche are now becoming pretty common. And we kind of thinking, okay, where's that come from?
That's the question.
And also sometimes we used to be able to spot who was getting legal advice from the letters that they wrote and the emails that they received. But now everybody's letters are absolutely magnificent because they're AI generated and they're all the same. So that's an important point to make, because people aren't as, you can't just assume, as you say, that they don't know what they're talking about, because they might, and also you could be wrong, which is why always do a proper investigation, because the amount of times I've spoken to a client on the phone and I've thought, well, this sounds absolutely slam dunk here. Absolutely go down to a disciplinary route with that. And then we've done an investigation and there was an absolutely clear, rational explanation for it.
Yeah.
And you don't, that goes back to not making any predetermined decisions and on outcomes, because you never know. So assume you don't know everything, go in with an open mind, and you'll never know what you might find. You might find that actually you're wrong, your processes are deficient, and you need to change something internally, and you'll think, well, actually, I'm glad I looked at it properly.
And I think it's something we discuss in maybe another session as well, is remaining consistent, I think, as well, to ensure that you've got that fair treatment across the board. If you're coming across the disciplinary, is, again, making sure your processes are fair for everybody, as I say, not sort of singling out one individual.
Look back what you've done before. I mean, we'll often say this to your members when they phone us. Has something like this happened before? And if so, what did you do then? Because if you ever do end up in the employment tribunal, they will always look at, were you consistent? And a reasonable employer will always be consistent and not treat anyone differently based on the same circumstances. So they'll look at those things. Did you follow your own processes, and did you follow your processes consistently in different environments, in different scenarios? And if you do treat people differently, if you keep good records and you keep good notes, you'll be able to justify why. And that allows you to remain consistent, because you can actually look back on your records and say, what did I do there and why?
Lovely. So just if one piece of advice you could give a business owner who's wanting to avoid disciplinary problems altogether, what would that be?
One thing, I would say, clear lines of communication, and so that if there is ever any issues, we can deal with them early and nip things in the bud. It would be like clear lines of communication and bringing things early.
Intervention, perfect. And ring the legal helpline.
Remember
to add that access. Okay, to be able to breathe here, but access to the legal helplines. And I think it's also important to note here is that all of our members, there's obviously certain terms and conditions, do have access to a £50,000 of legal expenses insurance. So providing they've followed the processes, they've taken the advice, done exactly what they should be doing, getting to the step of a tribunal, or even settlement, as you said before, as well mentioned, then there is an insurance policy that they get part of their membership.